Good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. We're having some technical issues here, but I think we'll be able to have the session. I just want to make sure that everything's working on your end. First offhand, I want to double check the audio to make sure that everything's coming through okay. So if someone could again type in, provided you hear me, uh, type in, yeah, okay, audio's coming through okay, great. Next thing I want to check is the video. On the screen should be Pennsylvania Office of Open Records, Basics of the Sunshine Act. If you can see that, then I think we're good to go. Okay, you can see it. That's fantastic. Yeah, I'm just working from a laptop here, and I was able to get the windows adjusted in such a way that I think I can see everything. Okay, so that's a good sign. Um, all right, let me regroup here and get started with the session. Um, Welcome. And a couple things that I want to cover before we actually jump into the content. As you can see, this is a PowerPoint presentation with me talking in the background. The PowerPoints are available on the Office of Open Records website. Go over to the training tab, scroll down, and you can find all of the PowerPoints that are used with our training. And you're welcome to use and view any of them. It's possible that you have some colleagues or friends who couldn't make it today. So, they can download them and refer to them at their leisure. If you're conducting any sort of localized training, you're welcome to use any of our content. Uh, Feel free to do that. Okay, someone is indicating they have an echo. I am not getting that from anyone else. Um, I think this is the best we can do at this point. Um, yeah, I think that's your system, Kathy. You're going to have to work that out on your end. Sometimes logging out and logging in again takes care of that. Um, Also, turn off your well, don't turn off your speakers. Turn off your microphone if you happen to have one that's on. That might be looping back through. The other thing is that I'm not sure if we're recording today, but many of these sessions are recorded. Most of them are recorded, and then they're also available on the website. If you can't find it on the website, you can contact the admin staff here, and many times they can just send you a link that will get you into the recording that you're seeking. Um, you can type in questions using the chat feature, obviously, and I will do my best to answer them as we're going through the presentation. But two conditions. First is we're talking about the Sunshine Act, so let's stay on point, and hopefully we'll be able to work through that. Also, the more brief you can keep your questions, the better. Occasionally, folks will type in several paragraphs, and it's just awkward for me to sit here and read through that while everyone else is waiting patiently. If you have something that is unusually complex or unique to your particular situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll do my best to come back to it, or we'll take the conversation offline. The contact information for the office is on the screen right now. You can send us an email or call into the office. Your first point of contact will be someone on the admin staff, and they are very well versed with both the Sunshine Act and the Right to Know law. Can usually get you headed in the right direction. If not, your query will be escalated to one of the senior staff, and they'll get back to you as soon as possible. And we can't provide legal advice. We are an information and training only office when it comes to the Sunshine Act. We have no enforcement authority, but like I said, we can try and get you to the right person who can hopefully deal with whatever questions that you have. Okay. Let's jump into the presentation, and I want to start by just briefly discussing why the Sunshine Act is important. And, we also refer to it as Pennsylvania's open meetings law. And I want to read briefly from the preamble of this law that was written back in the 1950s. Essentially, it guarantees the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, and decision-making of agencies because it's vital to the enhancement and proper functioning of the democratic process. Okay. Um, Very altruistic in its language, but yet it truly means a lot. I've talked about this before. In recent years, I've had the opportunity to travel, and I've been to some countries where, quite honestly, the idea of someone standing up in a meeting and having a public meeting at all in the first place and addressing their public officials uh, just wasn't even under consideration. I was in 2 years ago, I was in Guatemala, and Guatemala City, riding down the street and was passed by a pickup truck with guys dressed all in black, head to toe. You couldn't see their faces, carrying submachine guns. You know, you didn't know if they were the bad guys or the good guys, but I can bet you that they had nothing like the Sunshine Act. And it just made me appreciate what we have here in Pennsylvania. And, you know, experiences like that and the addition of talking to people all over the Commonwealth, both public officials and members of the public, as to how important this is, you know, the ability to stand up and talk with your public officials and the public, you know, same for elected officials. It truly is something that we're blessed with, and you know, I'm kind of like the main preacher here when it comes to the open meetings law, but yeah, we don't want to take it for granted. So I like to refer to the open meetings law as a three-legged stool. Oftentimes, people will call in and they'll want to know if, you know, did our public officials break the law? You know, is this legal, sort of thing? And while there are a lot of details and nuances to the public meetings law and a somewhat slowly growing body of case law, there are three things that at least I look for. That concern the spirit of the law. If these three items have been addressed, then I think for the most part, the agency is doing its best to comply. And the first is that they provided advance notice of when and where the meeting is going to be and how you attend. That how you attend can be very important when it comes to any online components, whether it be Teams or you know, Zoom or one of the other online platforms that might be used to address allowing people to attend online. Then the people need to be able to observe the deliberations. Now, the term deliberations has a specific definition, and we're gonna discuss that. Um, and then finally, is the public given the opportunity to comment prior to any decisions being made? And again, the term decisions has a very specific definition, which we're going to discuss, which raises an important issue at this point. Whenever you're trying to understand a law, whether it be the Sunshine Act or the Right to Know law, or for that matter, any other law in Pennsylvania or federal statute to that degree, uh, I always tell people don't forget to read the definition section. And the reason being is that, first offhand, you can have laws that are written with somewhat vague language, a lot of legalese. Occasionally, you'll read provisions that appear to conflict with each other. So many times, if you go to the definition section and do a deep dive into what do these words actually mean, it can shed light on the intent of the law, the intent of various provisions, and sometimes kind of clarify that otherwise conflicting or vague language. And the Sunshine Act is no exception to that. The Sunshine Act has a pretty intense or well, useful definition section that I'll be referring to here periodically. Okay, so let's move on and let's talk about exactly who is covered by the Sunshine Act. And this is language taken from the law itself. It applies to any state or local government body and all committees. Notice I have committees italicized because this is a fairly frequent issue that comes up. A committee met. Are they subject to the Sunshine Act? Next, and this builds on each point builds on the previous. It performs an essential government function. Okay, that's a somewhat subjective term. What is an essential government function? Well, some of it is just common sense. Um, I'll give you an example here. Let's say that the local girls softball team has won the state championship, and the elected board has decided we should have some sort of recognition and celebration of this accomplishment. Let's have a parade, and then we'll have a celebration at the local township park where we'll recognize the girls softball team. So we're going to appoint an ad hoc committee to organize things. Make sure the local high school bands are present, the fire companies and so forth. And this ad hoc committee is going to have to meet to make decisions on how to go about and organize this celebration. Okay, now as important and as great as this accomplishment is for the girls softball team, I would have to argue that having a parade and a cookout at the township park is not an essential government function. Okay, nowhere based in law are you going to find a statute that says you have to have some sort of celebration and parade. So I would be willing to bet that the gatherings of that ad hoc committee would not be subject to the provisions of the Sunshine Act. Okay, and then next is exercises authority to take official action. Okay, official action, another term, but you can find that covered in the definition section of the Sunshine Act. And within that definition, there is the clause making recommendations. So one of the aspects of official action is making recommendations. So if you have a committee that's performing an essential government function that then in turn comes back and makes recommendations to the elected board, that the gatherings of that committee would be subject to the Sunshine Act because they're performing official action per the definitions. Okay, so those are the main points that we use as guidance when looking at the law itself. Yeah, I thought it entered my head, but I think we'll just move on to the next slide here. Let's take a look at case law. You've got the Sunshine Act itself, but then you have an ever increasing body of case law where this is where there's been some sort of litigation and it's gone before the courts, and the courts, typically it would be the Pennsylvania Commonwealth or the Pennsylvania Supreme Court, has rendered a decision that then becomes guidance for the rest of us in helping us understand and how to apply the language in the law itself. Okay, if anything, I like to view it as, like I said, guidance and an interpretation of what the language actually means. So years ago, there was a case. It was called Ristow versus Casey. Casey being Governor Robert Casey back during his administration. And the question came up, are committees in our specific committees covered by the Sunshine Act? So this went to the Pennsylvania Commonwealth Court, and they took a look at different states around the nation and came up with a decision that provided some very useful language. Let me get into that a little bit. Again, the case citation is Ristow versus Casey. First offhand, the court asked the same question: does the committee have decision-making authority? Okay, now you're going to think, well, why wouldn't they have decision-making authority? Sometimes committees are appointed just to gather information for educational purposes. And I want to back up here. I see a question came up that I missed. Are municipal sewer authorities covered by the Sunshine Act? In most cases, they are. Okay. Any authority created by statute at the state or local level typically is covered by the Sunshine Act. Okay. Back to the slide at hand here. Um, so these committees that are appointed purely to gather information um, don't have decision-making authority. Or it might be that you want them to come back to the main board, maybe with some options, okay, for the elected officials to act on, but they don't make decisions in their own right. Sometimes, committees that do have decision-making authority, sometimes it might be like a public safety committee, personnel committees, and the like. It just depends on the municipality and what authority they have tasked the committee with, whether they have decision-making authority or not. Next, are the members appointed by the board and are they authorized to act on its behalf? Again, the question would come up, well, why wouldn't they be appointed by the board? In some instances, committees are what we call self-perpetuating. I always like to refer to public libraries because it's surprising how many times you find public libraries that were created and it predates the actual creation of the municipality. The libraries are older than the jurisdiction that they serve. Um, and then sometimes you have library boards where um, the original members were appointed by the elected officials, but then they're tasked with whenever there's a vacancy, the remaining board members are told, go out and find a volunteer to serve. We don't need to be involved. The elected officials don't pick the board members. Uh, so in that instance, the board members would not be appointed by the elected officials. And there's no real nexus between the operation of the municipality and the operation of the public library. So any decisions made by the public library aren't being made on behalf of the elected officials. All right. Well, in that instance, there would be a good chance that the library board in its gatherings would not be considered public meetings and would not be subject to the Sunshine Act. Now, it's interesting because most public library boards voluntarily comply with the Sunshine Act. And I had, some discussions with the state librarian that oversees all libraries, all public libraries in Pennsylvania a couple years ago. And it was an interesting discussion because they are doing their best to be transparent and voluntarily complying, even though they don't have to in many cases. Now, newer formed libraries typically would be subject, but I don't want to get into the weeds here. It's just an interesting discussion, like I said. Okay, and then we come up with the most important one, at least in my view. Are the recommendations, remember, recommendations constitute official action. But are these recommendations pursuant to statute, ordinance, or regulatory authority, where the end result is the enactment of laws, policies, or regulation? Okay. Now, what this means, at least from my point of view, is that not only are the gatherings of this group subject to statute, okay, there's a law that says they must meet, but the end result of whatever recommendations they make back to the elected officials is the enactment of laws, policies, and statutes. Okay, so let's go back to the example of the girls softball team. That ad hoc committee, okay, there's no statute that says they need to even exist, much less meet. And any recommendations, if any, that they would make back to the elected officials we should have a parade that runs down Main Street. Then they're going to turn left on Elm and go over to Market Street. Then they're going to travel down Park Lane to the Township Park. And we're going to have 3 bands in the parade and 2 fire companies. None of that is law. Okay, there's nothing that they're recommending that will result in the passage of a law that says, okay, this is how we run parades. It's simply a recommendation from an ad hoc gathering. This is what we want to do. Are you guys okay with it? All right. Now, if it would result in law, and let's say that there's a standing committee that meets periodically to review township ordinances to make sure that the language is up to date, they don't conflict with any new state laws, they're still relevant as far as the township is concerned. Okay, that is based in statute. And maybe they come back with a recommendation to change the parking ordinances. That would result in a new ordinance or an amended ordinance, okay? That would fall under this particular provision of this Ristow versus Casey. And I would have to say that the gatherings of that particular committee would be covered by the Sunshine Act based on the result of what comes out of that committee. Okay, now you're probably thinking I've explained this and it's as clear as mud. All right. Well, like I said, some of this is very subjective. And I'll just finish by saying that if it isn't clear, if you're unsure whether your committee would still be subject to the Sunshine Act, I'm going to say lean towards transparency and open up your meetings. And I would do this for 2 reasons. First is, this is the Office of Open Records. We're the government transparency office. So of course we're going to lean towards transparency. That's our job. That's what we do. That's what we advocate. But on a more practical sense, I think it just makes sense to do it because it's the easiest path. Sure, it's going to be inconvenient to open up a meeting to the public. You've got to advertise, you've got to have enough seats for folks to show up, you've got to allow them to comment, and maybe that's a pain for you. Maybe you're thinking, life could be easier if we wouldn't do that. But the other side of this that leads to a pragmatic conclusion, at least as far as I'm concerned, is that if you don't open up your meetings, someone could file a complaint and you could find yourself facing what I call the straight face test. And this is where you're standing in front of a judge explaining to them why you didn't open up your meeting to the public. And if the judge disagrees with your logic while you're trying to keep a straight face, it could get very painful for you. So you weigh the inconvenience versus the pain. And, I don't walk in your shoes, okay? I'm not a public official, but just knowing what I know, talking to public officials the way I have, I would lean towards transparency. Yeah, maybe it's inconvenient, but the cost of going the other way could be serious. Okay? Enough preaching. Let's move on. Okay, one of the questions that we have to answer is it a meeting? Is the gathering actually considered a meeting per the Sunshine Act? And, we will get calls, we'll get emails. I saw 3 of the township supervisors having breakfast together the other morning. Isn't that illegal? Well, no, it's not. It's not. They can get together, they can talk about the weather, they can talk about their kids, they can talk about the girls' softball team, okay? It's just that they can't discuss township business when they gather, provided, number one, there's a quorum. Okay, so let's go back to public meetings. And let me get a sip of coffee here quick. Okay, so as far as public meetings are concerned, First question that needs to be answered, is there a quorum? Okay. You need a quorum to conduct any official business. If you don't have a quorum, you can't vote. And therefore, it's not a public meeting. So if you don't have a quorum, you can still gather. It's just that you can't make any decisions and you can't, there can't be deliberation per se. Now, in order to make a quorum, with the exception of first-class townships and boroughs, you can phone in order to meet the quorum. Okay. So you can have less than a quorum physically present, but then additional members, elected officials, can phone in order to meet the quorum. That's okay. Now, if you're a first-class township or a borough, you must have the quorum physically present, and then anyone in addition to add to the quorum can phone in. Now, the phone call, or, I'm using phone in a generic sense. It could be an online meeting, like if you're doing Zoom or Teams or something like that. Now, you still must have a physical presence, okay? There has to be an opportunity for people to physically see their elected officials who are present. But anyone in addition can attend electronically. But the electronic connection, if you will, the phone call, must be direct. Everyone needs to be able to hear the person phoning in, and the person phoning in must be able to hear everyone else. What that means is that you can't have someone sitting there with the phone up to their ear relaying messages back and forth. Fred says this, or Fred votes this way. You can't do that, okay? If Fred is voting, I need to be able to hear what he's saying when he votes. Okay, questions have popped up here. Let me back up to make sure I didn't miss anybody. No. Okay, board gathering in an office before or after. Okay, that's an executive session, Valerie. We're going to be discussing that. Were there exceptions to the in-person requirements during COVID? Yes, there were. There was an emergency act passed. I don't remember. I think it was called Act 15 of 2019. I'm not sure of that, though. It was a long time ago. I forget. But that act expired. Okay. During that act, municipalities, agencies, I'll use the term agencies because that's more generic, were allowed to have online only meetings. When the Emergency Act expired, we went back to having physical meetings. Now, you can have an online component to that physical meeting where people join using Zoom or Teams or some other platform, but you must still have that physical presence. And not everyone agrees with that. However, I have, along with the executive director, testified at legislative hearings, and based on conversations that we've had with legislators, their expectation is that a public meeting is a physical meeting, okay, where a member of the public can stand up and address their public officials in person. Okay, so I'm basing my conclusions and on those conversations. Does that apply to committees as well? Yes, if the committee is subject to the Sunshine Act. Okay, there must be a physical meeting, just based on those conversations. And but fair time to those who disagree. Just so you understand that if it ever gets litigated, other arguments will come out. Okay, I just want to be fair to everyone in making that point. Okay. So is there a quorum present? We've covered that. Now, is there deliberation? Go back to the definition section. Deliberation is any discussion that can lead or that may lead to a decision. It doesn't say must lead to a decision or will lead to a decision. It says may lead. So if you are talking about the business of the jurisdiction, um, whether or not it leads to a decision or not doesn't matter. It's just that you're talking about agency business. So that would constitute a meeting. That constitutes deliberation. And then we come up to the next one. Is there decision making? Well, decision making would be a vote, because that's the official action that takes place. If there is a conclusion that leads to a course of action, that's a decision. Typically, it takes the form of a vote. And if there is decision making, that would be considered public meeting. And then finally, I want to say to public officials, just beware of email meetings. Sometimes you have a new board seated at the beginning of the year, and maybe some of the new members come from a business background. They're used to getting things done with email. And, they see an order of business here and they think, you know what, it would just be a lot more efficient, a lot easier for all of us if we just, I'll just put this out there in email and get an idea for what everybody thinks. Yeah, it is very efficient. Unfortunately, you run the risk of violating the Sunshine Act by doing so. Is a motion considered a decision? No. No. The result of a motion may be a vote. The vote would be considered the decision. Okay. So just beware of email meetings. Now, let me clarify though. You can't have an email to arrive at a decision on a policy level matter. You can use email to take care of administrative issues. For instance, let's say that the decision has already been made. Let's say that there was a public meeting with a public vote, 100% legal, to approve the spending of $2 million within the borough for street paving. Okay, so that decision's been made. All right. Now we need to decide where we're going to pave. And it might be this intersection, the 200 block of Main Street, the 300 block of Market Street, and the like. That is more administrative in nature because the policy decision has been made, and that was made in public. Now, figuring out how we're going to administer the big ticket item, the big vote, that's administrative in nature. And stuff like that, you can take care of using emails. But you need to be careful because it can be a very subjective and gray area. So, like I said, when in doubt, lean towards transparency. I'm not saying you can't use email. I'm just saying you need to be careful about how you use it and the level of discussion that takes place. And if you're thinking that, well, I can avoid having a quorum present by having separate email conversations with each member of the board so that there's never a quorum present at any one time, you're going to get yourself in trouble if you try that. Don't try to outthink the law because sooner or later it catches up to you. And like I said, you could be facing the straight face test. And I wouldn't want to see you there. Seems hard for a 3-person board, 2 of them cannot talk. Well, it depends, what it is that you're talking about. Any discussion regarding agency business should take place in a public setting. I mean, that's just the way it is. That's called democracy. Okay, let's move on. And what's not a meeting? Okay, well, I already talked about administrative action versus agency business. Administrative action is the details when the big decision has already been made. Then you have work sessions, conferences, retreats, and the like. Work sessions, okay. Let me talk about that briefly because there's nothing that prevents an agency from gathering, an elected board from gathering and having a work session. School boards do this a lot. They'll have a monthly business meeting. They'll also have a monthly work session. A work session is where communication is one way. I'll use school boards as my example, where the board gathers and the superintendent and the assistant superintendents, they all stand up and make presentations. And it's for the purpose of educating the board members so that they can make an informed decision when it comes time for the business meeting. Maybe they're talking, maybe the superintendent is updating them on a new federal program, maybe giving them an update on building projects, where we stand as far as the budget is concerned, and the like. Now, the individual board members can ask the presenters questions, and they can talk back and forth. What they cannot do is discuss the merits of the presentation amongst themselves, okay? Because then that would be deliberation, any discussion that may lead to a decision. So that discussion needs to be held off until the business meeting where the public would be present. And then there's no decision making during a work session because, again, that would be considered a vote. Okay, so work sessions are for informational purposes. Same with conferences and retreats. Okay, there's conferences all the time, and essentially it's for educational purposes. Okay, our work sessions are public. Are we violating the act if decisions are made? Okay, Greg. This is a very sore subject with me, and I'll just explain it. My take, and understand there's no case law that supports this. This is just George, and what George thinks doesn't mean a hill of beans here today. If you call it a work session, you are creating the expectation with the public that decisions will not be made, even though you're doing everything necessary to comply with the Sunshine Act. If I see it's a business meeting, my expectation is, okay, that's where the rubber hits the road. That's where our public officials are going to be discussing and making decisions. If you call it a work session, I'm thinking, okay, you're not going to make any decisions there. And there is a history, albeit a small one, of boards making major decisions during work sessions to kind of sneak things through. And that just rubs me the wrong way. And if it were put before a court, I'm not sure how they would rule on it, Greg. I don't walk in your shoes. Take your chances and see where it might fall. Okay. Personally, I wouldn't do it. But if you're doing it as a practice and it's not presented any problems for you, then you proceed accordingly. Okay. But good question. And like I said, it's just one of those things that raises a red flag for me, but maybe not for anybody else. Okay, let's move on here. Uh-oh. I just hit the wrong button and I didn't want to. Okay, I'm trying to advance slides on my laptop and it's a little wonky. There we go. Okay, I talked about the three legs of the stool, one of them being public notice. Okay, per the law, typically what happens is at the beginning of the calendar year, per your code, whether you be a township, borough, whatever, you have to meet. Usually it's like the first Tuesday of the year. So you, per the Sunshine Act, you have to provide 3 days advance notice of the first regular meeting, the organizational meeting. Okay, and then you include the dates for all the remaining meetings so that, let's say you typically meet the first Tuesday of the month. Well, then you would list all of those dates through the remainder of the calendar year. It has to be a legal notice in a paid newspaper of general circulation. All right. I realize that given structural changes that are taking place in the news media, this is becoming harder and harder to do. Um, but until the law is changed, this is what the law says, and we have to comply. Uh, Newspaper articles, maybe a new board was elected and the local newspaper does what's called a puff piece, and it just happens to mention that the board meets every first Tuesday. That doesn't count. It has to be that legal notices. Websites, okay? I think using social media is great. We're seeing, more and more the public expectation is to get on the internet to find out what their local government is doing. So go ahead and use your websites to list the dates of your meetings. Unfortunately, you still have to put a legal notice in a paid newspaper of general circulation. Um, and then those weekly or biweekly or thrice weekly sales circulars that fill up our mailbox, they don't count because they're free. We're not paying for them. And then you also must have a posting at the actual meeting site of the dates for your meetings. Uh, Agencies are allowed to have special meetings. Let's say something comes up that can't wait until next month. Maybe there's a grant program that you discovered where there's a deadline, and you're going to need the decision to participate in the program, um, and it needs to be made before you can have your next regular meeting. Well, the Sunshine Act recognizes special meetings where you've got to follow all the same provisions. It's just that now the advance notice decreases to 24 hours prior to the call to order of the actual meeting. And then you can have emergency meetings. Emergency meetings are where something happens that a decision needs to be made right away. For a bona fide emergency meeting, there's no requirement for advance notice, and you can have it without complying with the Sunshine Act. I always like to use the snowplow example, where, we're a small township or borough. We've got one plow, okay, and that's worked out fine for the last several decades. But it's an old plow, and we've put a lot of repairs into it lately. And finally, something broke on it that just can't be fixed. And the weather forecast says we've got a storm coming, so we need a new plow right away. Turns out that down the road, they've got one sitting on the lot. We can have it in our garage, tomorrow if we vote to approve the purchase of one. But we need to do it now. Okay, so we have an emergency meeting, bona fide emergency. And we vote to approve the purchase of the new snowplow. No notification requirement. However, I've described a bona fide emergency. Do not try to create an emergency to avoid complying with the Sunshine Act. Again, don't try to outthink laws because sooner or later it catches up to you. You may think that you can do it on the sly, on the down low, but there are no secrets when it comes to government operations. Eventually, it all comes out, and you could find yourself in a lot of trouble. Trying to advance a slide here. I don't want to do that. Uh-oh. Now I just messed up the order of the slides. What am I doing here? Okay, I might have to skip over a slide here. Okay, public notice. Let me try and figure out where I was. Okay, yeah, boy, did I mess things up. Oh, wait a minute. Let me hit the back button. Aha, okay. Sorry about this, folks. I'm talking to myself and trying to work from this laptop. Okay, public notice, more public notice. Okay, moving on. Yay, agendas. That's where I wanted to be. Okay, a newer provision of the law discusses agendas. Okay, and agendas need to be put out there before the actual meeting. So essentially what the provision says is that all agencies must post an agenda of issues to be deliberated on, meaning any discussion that we intend to have, or any planned official action, any votes that we intend to take, at least 24 hours prior to the public meeting. Okay, and this includes regular and those special meetings. Okay, so whether it's 3 days advance notice or 1 day advance notice, agendas are 24 hours, 1 day advance notice prior to calling the meeting to order. Okay, doesn't include those work sessions, which is another reason, Greg, why I have an issue, because the agenda provision doesn't apply, even though you're otherwise complying with the act. And it doesn't apply to conferences or executive sessions. I'm going to discuss executive sessions here coming up. Okay. It requires that you post the agendas on websites if you have them. And some agencies don't use websites, they use Facebook. Well, then you would use the Facebook page in lieu of your website. You have to have the agenda available at your agency office. You have to have it posted at the meeting site, and then you have to have copies available at the actual meeting itself. Now, the question has come up, how detailed should our agenda be? Okay, because I think when this all started, there was a tendency to make the agendas as brief as possible, and then people complained, well, I don't know what this means. Now, this is me, okay? There's no case law on this, but this is just my take on it. And if you were to say, well, this is what George says in front of a judge, first thing they're going to ask is, who the heck is George? Okay, and then they're going to say, well, why does he carry any weight? And you're going to have to say he doesn't, okay? But this is just me applying some common sense. We're going to talk about executive sessions here in a little bit. And the issue that one of the cases that comes up with executive sessions is how detailed does the announcement need to be? And there's language that was used in that particular case. It's called the Reading Eagle case, where the court said you need to provide enough detail so that the public can trust you're doing it for the right reason. Okay, well, that, again, that can be very subjective, but it creates the sense that you've got to have enough detail in your agendas so that the public has a general idea as to what you're talking about. So if you just put down, we're going to discuss the bond issue, okay, I have no idea what that means. Okay, but then if you expand it to include a couple sentences, we're going to discuss the bond issue relative to the reserves that we need in order to, I don't know, in order to meet our self-insured requirements. Okay. Then I do have a general idea as to what you're talking about and what's going to be discussed at the meeting. Okay. I have, I can make a decision as to whether I want to come to the meeting or not, because how is that going to impact me as a taxpayer, as a citizen within the township or the borough or the city or whatever? Okay, so you want to provide enough of an explanation on your agendas so that the standard, common sense citizen has a general idea, a general understanding as to what it means. Moving on, let's talk about the timelines for these agendas. Okay, 24 hours. So prior to 24 hours, if you have an agenda, you can make any changes to it that you deem necessary. 24 hours up to and including the meeting itself, the only changes you can make to the agenda are for emergency or what's known as de minimis changes, where there's no expenditure of funds and you're not entering into any contracts. Okay. And the same exists during the meeting. If something new comes up where you want to amend the agenda, it can only be for issues where it's either an emergency You're not spending any money and you're not entering into a contract. Now, if your change meets that criteria, then there's two things you need to do. First is there needs to be a motion and approved by majority vote to amend the agenda during the meeting. So you would do that. And the reason you do this is because then it becomes a matter of public record that gets recorded in the minutes for the meeting, and minutes last forever. And then you have your discussion, your deliberation. And remember, deliberation may lead to a decision, a vote. Well, it may not, okay? So if you vote to change the agenda, that gets recorded in the minutes, then you have your deliberation, and the result of the deliberation may be to do nothing, okay? And that's fine, okay? You can decide to vote on something, or you can maybe decide, oh, we're not going to bother to vote. But if you do decide to vote, then that needs to be a second motion. And again, the vote gets recorded in the minutes, which is the official record. Okay. A good case to review is Coleman versus Parkland, where just real quick, what happened is a school district that day, the union for the Teachers Association ratified a new bargaining contract. So the board, even though it wasn't on their agenda, they decided, well, let's vote to amend the agenda so that we can approve we can ratify the contract on our end. We'll vote to approve the contract since the Teachers Association did it this morning. Okay, so they went ahead and did that. Someone filed a complaint, and the court ruled that no, because you're entering into a contract, you're not allowed to do that. This should have been on the agenda. Okay. And reason I emphasize this is because prior to this, there was a different understanding as to what elected officials how they could amend and what they could amend the agenda for. The Parkland decision changed that. So I think it's important to be up on that. You can only change 24 hours prior or during the meeting for de minimis issues. Okay. Then during the meeting, let's say you do decide to amend the agenda, you've got to announce prior to any official action why you're changing it so that the public understands. And then the amended agenda, let's say you did go through that exercise and change your agenda so that you could vote on a de minimis matter, that amended agenda must be reposted within 24 hours. Then the question comes up, well, how long does it need to be posted for? It's not in the law, and we don't have any case law on it. But again, this is George talking, and I already explained how much weight my opinion carries. I use 24-hour logic, okay? 24 hours prior to the meeting, you have to have the posting. So I would think 24 hours once it's posted after the meeting. After 24 hours, you can take it down. Hey, if somebody complains and takes it to a judge, the judge may disagree with me. But, until that changes, that's my recommendation. Okay. And then, like I said earlier, the minutes reflect the official record of the meeting, so they need to reflect any changes that were made to the agenda. Okay. Moving on, and I'm going to try not to mess up the slides this time. Yeah. Public comment. Sip of coffee. Okay. Public comment is the second leg of the stool. It can be limited to residents and taxpayers. Okay, this is in the law. Sometimes you will have people come in from out of town. They want to address the board during the public comment period, and the board can say, no, we're only allowing taxpayers and residents of our jurisdiction, of our municipality, to make public comment. People have the right to comment on issues that are or may be before the board before any vote is taken. Okay, that term may that's in there. Well, that's somewhat problematic because it opens your public comment up to anything that a person may want to discuss. Maybe you're talking about bond issues and you're getting ready to vote on it, so you're allowing public comment, and the guy down the street wants to talk about potholes. Well, as the law stands, he can talk about potholes. However, the board may also establish reasonable rules for public comment. Typically, this would refer to like time limits. Excuse me. Everybody gets 3 minutes for public comment. But there is a practice of specific versus general public comments. Let me see if that's the next slide. No, it's not. Okay, let me talk about specific versus general. This is not in the law, okay, but it is what we will describe as a best practice. It was brought to our attention several years ago that there were some municipalities that were actually holding multiple public comment periods. The first, they were saying, we're going to limit your public comment to the matter at hand. Okay, so you can have public comment, but please, we're only talking about the bond issue. And then they would have a second public comment at the end of the night where if someone wants to get up and complain about potholes, now's your chance. Okay, you can do that. This seems to work out for a lot of municipalities. Okay, we're not saying you have to, and you're not going to find it anywhere in the law, but if you're having some issues with public comment, maybe this is something you want to take a look at. It may work out for you. It may fall flat on its face, but we're just putting it out there as a suggestion. Okay, a couple questions have come up. Does the restriction on public comment extend to social media? Not as far as the Sunshine Act is concerned. You've got to remember that we have a right to free speech. This may be helpful. A couple years ago, there was a school district that was limiting public comment. It had to be germane to what the board was discussing. And there was an instance where a solicitor or an assistant solicitor, someone like that, was shutting down public commenters because he felt they were going off topic. And so he was saying, you're done. And you can search for the video. I think it was the Pennsbury School District. It led to a federal case where the litigants were claiming that the school district violated their First Amendment rights to free speech. The initial court decision agreed, and then ultimately it was settled between the parties out of court. But that being said, you want to be very careful about any action that's taken against public comment, whether it be taken during a public meeting or in response to just social media comments. Okay. You can establish rules that basically follow, no public attacks, no bad language, and so forth. But, there is language out there, case law, that says you don't have to be respectful to public officials. You can speak your mind in any manner you deem fit within reason, and it becomes very subjective again. But it's very thin ice, okay? And I would caution you against, if you're a public official, whatever action you take to stymie public comment, okay? It's just be very careful because it can get very expensive. Okay, if the public comment period is on the agenda, can comment also be after a motion and second before roll call vote? That, Valerie, is up to the rules that are used by the agency to conduct its public meetings as to when they want to have their public comment period. Okay, and typically there's nothing that guides that from a legal perspective. Typically, it's in their rules of order that they adopt as policy for how they conduct their public meetings. Um, okay, good question, by the way, and they're all good questions, but yeah, keep them coming. Okay, uh, executive sessions. Well, let me make sure I covered everything with public. Yeah, I did. Okay. So, executive sessions. Now, executive sessions are gatherings of the elected board that are outside of the public eye so that they can discuss sensitive issues that, involve sensitive or confidential information that typically you would not discuss in a public setting. Now, they can be held before, during, or after a regular open meeting, or they can be announced that we're going to have the executive session tomorrow night at a future time, without the public present. Okay. Um, they need to provide the complete reason for why they're going into executive session. And this is where I referred to that case, Reading versus the Reading Eagle. What happened is the city of Reading would simply announce, we're going into executive session for personnel reasons or for legal reasons. The Reading Eagle, which is the local newspaper, said, that's not good enough. You have to tell us more. So they took them to court, and eventually it ended up in the Pennsylvania Commonwealth Court that led to language that said, you have to provide enough of a reason so that the public can trust you're doing it for the right reason. I'm really paraphrasing there, but it's good reading if you want to get a better understanding of it. It goes into the fact that, look, when you're going into private session, democracy no longer exists, okay, because you're doing things in secret. But if you're going to do it in secret, you need to explain to the public why you're doing so in order to not violate that public trust. It's really good language, and I think it provides some good guidance as to the spirit of the Sunshine Act and why agencies should not use executive sessions to violate that spirit, because it all involves the public trust. Okay. Um, Okay, Valerie. Township solicitor told me that the case was not valid with other cases since. Okay, I'm not exactly sure what you're talking about there, but I would have further discussions with your township solicitor because, as far as we're concerned, the Reading Eagle case and that case law, um, does have standing. And if I were called into court, I would use it. Okay, so personnel reasons and legal reasons are not good enough. According to the case law that is currently in existence, yes, that's the point that I'm making. So that if you use legal reasons, rather than say just legal reasons, we're going into executive session so that we can discuss legal strategy with our solicitor regarding the suit that has been filed against us by XYZ Corporation on the zoning matter, or personnel reasons. We're going into executive session so that we can discuss possible disciplinary issues, disciplinary matters involving one of our employees. Okay, that's enough in my mind. Okay. Uh, Okay, Greg, it is unrealistic to think that in executive session, some sort of decision wasn't made simply by the conversation. Can a basic decision be made with the official vote? Well, yeah, Greg, okay. Um, Within an executive session, you can poll the members. John, what do you think of this? Margaret, uh, what's your take on the facts that have been presented? Okay. And you can reach a conclusion as to how the vote will transpire. But the point being, the actual vote, Greg, needs to be made in a public setting. Okay, if you follow me. You can't just everybody decide on a course of action in executive session and then not memorialize it with an official vote. The result of the executive session, if you are going to take action, needs to be official. So that using the personnel reasons as an example, you hear everybody out, you make a decision, and your HR person is going to make sure due process has taken place, and then you conclude the executive session after maybe you informally polled everybody, and then you come out into public session and you would take the actual vote. I make a motion to suspend John Doe employee for 3 business days due to a rule infraction. And all in favor say aye. Okay, and then that gets memorialized in the minutes. Okay, yeah, you understand. Okay, so yeah, I think you raise a very good point. There's nothing stopping the officials in executive session from kind of getting a feel for how everyone's going to vote. It's just that the actual vote takes place in a public setting. Just so there's no misunderstanding. And if you fail to take the public vote, that could get you in legal trouble, which, you're public officials, you probably understand this. Okay. Executive sessions, the reasons you can go into executive session. Okay, well, personnel matters that involve hiring, firing, discipline. I should say that it involves specific employees or specific positions. Personnel matters of a general or policy nature must take place in a public setting. So if you are discussing, for instance, leave policy or I don't know, disciplinary policies. Okay, that's public. But discipline involving a specific employee, that's private and can take place in an executive session. Labor negotiations, yeah. I mean, your strategy for bargaining, you don't want to do that in public because then you'd let your bargaining unit know what your strategy is going to be. So you can do that in private. Purchasing, leasing, or selling property. Yeah. When you're talking about property valuations before you list them for sale, yeah, you wouldn't want to do that in a public setting because then you're showing your hand. Consulting with counsel about litigation or legal strategy, avoiding violating privilege. Okay, let's say something occurs in a public meeting where one of the public officials says something. All of a sudden, your solicitor's eyes get real big, and they say, "We need to go into executive session." Okay, and then they go into executive session so the solicitor can provide legal advice and guidance, basically telling the public official you shouldn't say that in public. Okay. That's considered privilege, okay? And you can do that in private. Discussing university admission standards, I don't know. I wasn't around in 1952 when they wrote this. Discuss emergency preparedness, like homeland security stuff and evacuation plans and the lockdown policies for the local prison, stuff like that. You can do all of that in executive session. Okay, moving on. All right, violations of the act. We always get these calls, and I hear the administrative staff when they get them. Someone is complaining about what their public officials did in a public meeting last night, and they want the Office of Open Records to investigate and do something. Well, there is no enforcement agency for the Sunshine Act. Let me back up. A question just popped up here, and I want to make sure I don't miss it. What about commissioners discussing COLA raises and contributions for all employees' health care? Okay, that, without knowing all the details, Nathaniel, I would think that's something that you would want to discuss. For the most part, without knowing the details, I'm going to say that's something that should probably be discussed in public because you're talking about a class of employees. Now, COLA, cost of living, there's nothing secret about that. If it were a performance-based raise, I think I could argue that maybe that should be discussed in private. But cost of living, that's based on indexes and so forth. My gut tells me that should be discussed in public. But again, please don't take this as legal advice. Maybe you want to discuss it with an attorney or the commissioners themselves to find out what their logic was if they failed to discuss it in public. But that's my gut feeling. Okay. The point being, back to the slide, neither the Office of Open Records, the Attorney General, or any other agency has enforcement authority when it comes to the Sunshine Act. The procedure is that, first offhand, let me walk you through it. This doesn't have to happen, but any member of the public present at a public meeting can stand up at any time and respectfully say, I believe you're violating the Sunshine Act. Okay. And they're not out of order. They're not violating the act itself, as long as it's done, in a respectful manner. Now, the board can cure violations. Okay, so let's say that someone does that. They stand up and, going back to what Greg was alluding to, and the board says, you know what, you're right. We kind of decided what we were going to do in executive session, but we forgot to vote because we got sidetracked with some other issue. So we're going to vote now, and we're going to make it official. Okay, they have cured the violation. Okay, perfectly legal. You can do that. They can actually wait until the next meeting, and provided no one files a complaint in the meantime, they can go ahead and take action to no harm, no foul, correct their previous mistake. And the law allows that. Now, what if the board says, no, we disagree. We didn't violate the Sunshine Act. Well, then the public has 30 days in which they can seek legal relief before the appropriate court. Now, if it's a local agency like a city, authority, township, school district, you would go to your county court of common pleas, and it depends what you want done. And every court is different, it seems, in all 67 counties in how they operate with the Sunshine Act. There are some that will have a process in place. There are others that will look at you and say, Sunshine what? And have no idea. But essentially, it depends on what you want to do. And the court will respond accordingly. Now, if you are alleging some sort of criminal intent, you could also take it to the district attorney's office, and they will investigate it from a criminal perspective, but they will not rule on the Sunshine Act violation itself because that is a civil matter. And the courts have great leeway in what they can do. Typically, they will hold a hearing. And the parties, when I talk about the straight face test, well, the parties will stand up and explain their positions. If the judge disagrees with the agency, they have great leeway in what they can do. And in recent years, we've seen some imaginative results. They can void a vote. They can simply slap them on the wrist and say, yes, the law was violated, don't do it again. They can void an entire meeting. We saw that happen in Scranton 2 or 3 years ago, where there were some technical issues with a meeting, and they voided the entire meeting. They said, you have to do it over. If it's particularly egregious, they can levy fines. And if that's done, the fines need to be paid by the officials. The agency cannot pay the fines on their behalf. The first violation is up to $1,000 each. The second violation is up to $2,000 each. So remember when I was saying about lean towards transparency and open your meetings just because it's a practical approach? This is why. It gets very painful if a judge decides to levy violations. Okay. Does a perceived violation need to be discussed with the board first? No, you can go straight to court if that's what you want to do, and read the law because like I said, you have 30 days to do it from the actual violation itself when it occurred, or up to a year. Let me make sure I got this right. It's up to a year with that 30-day provision. After a year, whether you discover it or not, it's you've gone beyond the statute of limitations, but it's in the law. Okay, and take a look at it. Okay. Then, like I said, judges using imaginative solutions, they have ordered training for public officials and training for public officials on the Sunshine Act. And our office has gotten involved with that, where they said, their decision was, okay, you've got to go get training from the Office of Open Records. We're more than happy to do that. So we conduct the training. I've done it for various public officials. And then we provide communication with the court saying that, we held training for these public officials in compliance with your order, and, all provisions of your order have been met. And then it becomes a matter of the court's record. And moving on. Okay. So not a lot of case law, not a lot of activity, but in recent years, we have seen more activity. And it's made it kind of interesting. Okay, then just before we wrap up here, some miscellaneous points to cover. Any public meeting, you've got to have minutes, okay? And that's written in, there's a reference to it in the Sunshine Act, but it's also part of the codes that govern these various agencies and their jurisdictions. You're going to find references to minutes because that is the official record. So as far as the Sunshine Act is concerned, any votes need to be recorded in the minutes. And if it is a roll call vote, you need to break it down by individual member, how they voted, yay or nay. The public can record meetings unannounced. And I still find references on websites when we do random searches and occasionally news stories where jurisdictions have this requirement that if a member of the public's going to record, they need to announce it ahead of time. They don't, okay? That would be inconsistent with the language of and case law related to the Sunshine Act. I can set my smartphone on record, put it in my pocket, come into the public meeting, and I don't have to tell anyone. There's no expectation of privacy at a public meeting. Now, what if the agency is recording the meeting? Okay, well, typically they do that in order to have accurate minutes. So as long as the agency, well, first offhand, what I recommend is at the beginning of the meeting, when the chairperson is making the general welcome and announcements, that they include something to the effect that this meeting is being recorded, or it may be recorded by a member of the public, and there's no expectation of privacy. Now, the agency recording, getting back to that, becomes a public record as soon as the meeting is concluded. And that recording then is subject to the right to know law until such time that the recording is disposed of. Okay, and there are various rules on when and how you can dispose of those recordings. But, they become a matter of public record. The minutes are also a matter of public record, but there's a provision in the right to know law that exempts minutes. It basically defines them as draft until the next regular public meeting. Okay, and then they become discoverable under the right to know law. Okay, so then we've successfully made it to the last slide, despite our technical issues and me messing up the slide order. But, if you have any more questions, now's a good time to get them in. Okay. Is it public? Okay. Oh, they're all coming in and advancing the chat faster than I can keep up with it. Let me back up here. Is it public name and subject only? No description of their comment. Oh, Valerie. Okay. All right. This is another one of those George things. Okay. And I'm going to bring your attention to the language in the law itself. Now, I am the only person in Pennsylvania who has this opinion. Everyone else disagrees with me. But if you look at the language in the Sunshine Act, I think it says whenever it's referring to public comment, it uses the term comment. Okay. And then when you go over to the reference to the minutes, okay, the minutes say something like the date, time of the meeting, and then there's a reference to the minutes must reflect any testimony provided, and it doesn't use the term public. I think it uses individual, or I may have them reversed. But anyway, there is a difference. In my mind, there is a difference between comment and testimony. Okay. Comment is when you have the public comment period, the person stands up and gets it off their chest what they want to say. Testimony is when the person is sworn in and they're making a sworn statement before the elected officials. Okay, to me, that is different. Like I said, so the result is that if I were in charge, your minutes would not have to have any reference to public comment. It wouldn't have to have who commented. It wouldn't have the subject or anything. Okay, that's my opinion. But George's opinion doesn't mean very much here. Because of that reference in the minutes where in the Sunshine Act, where it's referencing minutes, it doesn't use the word comment. It uses the word testimony. Okay, that's my logic. You can agree with me. You can say I'm full of beans. You can have a discussion with your solicitor over it. And like I said, no one agrees with me on that. But you asked the question, so that's my answer, and I'm sticking to it. Okay, next one, Nathaniel. Does the board have the ability to add additional legitimate executive session items on short notice during the meeting to an already advertised agenda showing an executive session for other previously listed items? Nathaniel, my official answer is I don't know because it's never been litigated. But applying what I'll call George's common sense, I think as long as an executive session is not a public meeting. Okay, let's make that distinguishment there. So I don't think the agenda rules apply to an executive session. As long as the board adequately explains what they are discussing during the executive session and they show an attempt to meet the spirit of the Sunshine Act, I think they will be okay. I don't think the specific provisions related to agendas apply to executive sessions. I just think that they need to tell the public what it is they're discussing, and that if there is a change, then they need to make sure that change is made public as well, either before, during, or after the public meeting, and when they have the executive session, if that makes sense. Okay, moving on. If a board member is not present at a meeting, can they move, second, or approve those minutes at the next public meeting. I would say I would feel more comfortable reading the specific codes that govern those boards, whether it be city, township board, borough, school district. But as a general statement, I would think that they can, okay, even though they weren't present. I'm not aware of any reason or any provision that says they can't, but I'm very reluctant, Jennifer, to provide you with an answer without having the opportunity to do some research on that, because there may be provisions within the codes that, yeah, that would change my answer on that. Okay, last slide, purely for informational purposes. If you have any more questions, get them queued up here. I want to direct you to the website. Okay. The website is updated 6 days a week. It's the best government website you're ever going to see. It's got guides for citizens, guides for agencies. There is a page just for the Sunshine Act. We're tasked with providing training and guidance. This is what we're doing here today. And there's like FAQs on the Sunshine Act. You can call in with your questions, send us emails. We can't provide legal advice. I hope I've made that clear with some of my wishy-washy answers. But we can try and get you steered in the right direction. There's not a lot of case law on the Sunshine Act, so it's limited in what we can say. But, we can kind of get you pointed to the appropriate court that will provide a definitive answer for you. And, I really suggest that if you have questions, don't be shy about talking to your solicitors. Don't be shy about seeking legal help from other parties. But we'll do the best we can with helping you out. I want to thank you all for your participation here and your patience while I was, working from a 10-inch or 12-inch laptop as opposed to a 90-inch screen that's sitting in front of me, being pretty much worthless this morning. But you've done a great job, great questions, and we'll be back in 2 weeks where we're going to discuss the basics of the right to know law. I hope you can make it back, and we'll see you then. Okay, folks, have a great Thanksgiving, by the way, and stay safe out there with the wet roads tomorrow. Take care.